Thank you, and very good morning to all of you. I know it's a Saturday morning, right? And the topic this morning is going to be duties of an architect from a legal perspective. Of course, when we talk about legal perspective, it's going to be rather technical and dry to you folks. I think you'll probably find Lulu's talk much more interesting than you're going to hear for the next 1 hour or so. So we will start off with the basic things. Some of the things that we're going to discuss this morning may be quite obvious to you. You know, they are pretty basic that you probably have gone through over and over again. But let's just go through general duties of an architect from a legal perspective. First of all, of course, you have duties in a contract. Yeah, duties of an architect in contract. So the scope of an architect's duties is typically outlined and governed by the terms of the appointment or the contract. You will find everything is set out in your contract, and a lot of you would have gone through it on a daily basis. For example, if an architect is engaged solely to design a building, the duties to client is limited to the design aspect only. If an architect is engaged as a contract administrator, usually by the employer, the responsibilities extend to overseeing the construction phase up to the completion of the project, which includes issuance of CCC and CPC. An architect will be liable to the client if the duty is breached. I mean, that's basic, of course. There are also duties in tort. An architect also owes the client duties in tort. It is negligence and so on, right? The architect's duty in tort, the contractor and subsequent owner of the property, arises if there is sufficient degree of proximity in the relationship. Again, it's technical. Proximity means there is closeness as far as law is concerned, from a legal perspective, sorry. Of course, if you are engaged by way of contract or if you're asked for advice, there's definitely proximity because they're relying on the architect as far as advice, even drawings and design, and contract as well. So it doesn't mean that if there's a contract between an architect and an employer or an architect and a different party, there cannot also be liability in tort. That it can overlap, sometimes it can coexist. However, we will go through a case law where it talks about the contract having provided remedy, therefore the architect is not liable, but we'll come to that later. The existence of a duty of care and the scope of such duty will be on a case-to-case basis, depending on the facts and circumstances. So it's always on a case-to-case basis, which is why no lawyer can tell you this is the exact position or one size fits all. No, it doesn't. You have to look at the facts of the case. You have to look at the relationship of the parties, what is required from the architect, what did the architect deliver, and where did it go wrong, if at all things went wrong. So you really have to go through the facts and you have to apply the facts to the law and case law, which is why it is not something straightforward. May all relevant parties a non-delegable duty of care. This we'll discuss later because we want to focus on the non-delegable duty of care, which is even more complicated than a straightforward negligence. And the reason why we're going to discuss it later in more detail is because there was a recent federal court decision, although it's on medical negligence and the liability of a hospital for what one of their specialists did, it has extended the principle of non-delegable duty, we think, the legal profession thinks, right? And there, the judge who delivered the decision has actually sort of dismissed all the other defenses or exceptions to the non-delegable duty of care. So you may want to then ask or consider later, how does it apply to an architect? Although that involves doctors and hospital. here I just want to pause and just want to say that when you come across a case law, right, it may just involve a doctor, a contractor, or any other profession or party. And it does not mean that it cannot apply to different professions, for example. You have to just extract the principle that is stated in that case law, right? So a lot of people that we have come across after that recent decision in 2024 say, yeah, but that only concerns hospitals, so we're not bothered. No, it may, but that's what lawyers will do. They will then try to extend that principle to other areas and other professions as well. So that's where you may want to be informed and be aware of what the principles are in case laws that come out, right? So we'll go on. As with all other professionals, the standard of care to be observed by an architect in tort is that of an ordinary skilled person exercising and professing to have that special skill. So this is a blanket sort of general principle when it comes to tort. So when people rely on architects, they're relying on as an ordinary skilled person exercising and professing to have that special skill. So there are many facets to this. Generally, as an architect, you all possess certain skills. Because when you come out just like lawyers or engineers or any other professional, you have that general skill. So you can't run away from that skill. So some basic stuff every architect ought to know. The second part, or the other part, is when you hold yourself out as a specialist in a certain field, your skill then becomes even more. So if someone comes to an architect and asks for general advice, it is limited to that ordinary skilled architect. But if you hold yourself out to be a specialist in a certain area, designing, for example, spacecraft or whatever it is, then you'll be held to have that skill. So when you hold yourself out, you must ensure that you're able to deliver that skill that you have represented to the person that you're dealing with. So that's where some lawyers may say that do not oversell your skill. That applies to any profession, any professional, any product, for example, right? So whatever you say, for example, Nippon or any other products in the world, you must be able to hold to what you have represented. Because, for example, as a layman, I would think paint is paint. But we do not know that all this exists. Like you may know as an architect. So when someone says that, yeah, I can repair your building because I'm a specialist, or someone says, use this product, I guarantee it, then you will be held to that. Right? So all of us, everybody wants to, as far as our profession is concerned, as far as skill is concerned, we always want to say that, yeah, I have this qualification, I can do this, I can do that. But you must be able to hold to it. I just want to emphasize that. So ordinary skilled person exercising and professing to have that special skill. But if you say you are specialized in designing, for example, Bali style resort, so your skill will be ordinary skilled person exercising and professing to have that skill and not beyond, but not lesser as well. Okay. So let's just generally look at some case law on architect's duty of care. And this was decided in the case of Sutcliffe against Thackrah. Don't worry about the citation, it's not relevant. So here, it was a claim by an employer against the architect who he had employed to design a house. There was a contract between the building owner and the architect, which acknowledged that, amongst other things, the latter would be concerned with the rebar form contract. Subsequently, the employer entered into a contract with a firm of builders, which was in a standard rebar form. The rebar form also contained condition 35.10 10, providing for arbitration. The architects were appointed architects and quantity surveyors, and during the course of the works, issued interim certificates. Where was I? Can you hear me? So that appears to be also, I wouldn't say a check coming. Thanks. Can you hear me better now? Yeah, I wouldn't say that it's becoming a trend really, but you see it more often where parties bring everybody, they name everybody in action. I've got a couple of housing projects, and the engineers, architects, directors of the developer, shareholders of the developer, who happens to be a public listed company, were all named as defendants. That also depends on what the lawyer advises the client. So as an architect, sometimes you may find yourself in an unenviable position where you'll be wondering, why have I been sued? Why have I been brought as a party? But you see it more often now. So like, for example, this is one example. Sometimes when a company or a person is wound up or has gone bankrupt, the party has got nowhere else to go. So they try to extend or reach to parties which may not be liable at the end of the day, but you have to go through the process, right? Of course, it's absolutely frivolous. You can take out an application to strike it out, but that seems to be happening. So for example, here, I think that's what happened. The company, the original builders went into liquidation, and the employer brought an action against the architects in negligence and breach of duty. And this is what the court observed. In summarizing my conclusions, this is a judge, quoting a judge. I must preface them by the observation that each case will depend on its own facts and circumstances and on the particular provisions of the relevant contracts. We've gone through this. But in general, any architect or surveyor or valuer will be liable to the person who employs him if he causes loss by reason of his negligence. If he causes, right? There will be an exception to this, and judicial immunity will be accorded to the architect or surveyor or valuer has by agreement been appointed to act as an arbitrator. These are totally separate things. If you have been appointed by contract to act as an arbitrator, then you cannot be liable for negligence. But if you're acting as an architect, of course you can. There may be circumstances in which what is in effect an arbitration is not one that is within the provisions of the Arbitration Act. The expression quasi-arbitrator should only be used in that connection. A person will only be an arbitrator or quasi-arbitrator if there is a submission to him either of a specific dispute or of present points of difference or of defined differences that may in future arise, and if there is an agreement that his decision will be binding. The circumstance that an architect in valuing work must act fairly and impartially does not constitute him either an arbitrator or quasi-arbitrator. So this is the usual duty of an architect where you are employed to certify the sums, certify certificates and issue it. It's different from where you are employed or you're contracted to act as an arbitrator, right? So the circumstance that a building owner and the contractor agree between themselves that a certificate of an architect showing a balance due is to be conclusive evidence of the works having been duly completed, and that the contractor is entitled to receive payment does not of itself involve that the architect is an arbitrator or quasi-arbitrator in giving a certificate. Chambers against Goldthorpe was wrongly decided. The fact that in the present case, the architect had, in an interim certificate as to the amount due, to record the total value of work properly executed and of materials and goods delivered, did not constitute him as an arbitrator. He incurred liability for his negligence in over-certifying. So, I mean, that's basic to all of you, I'm sure, when you're certifying something, when you over-certify, or when you issue the CCC, or because sometimes you get it, I mean, not get it all the time. Sometimes, especially those days, you get developers and architects working hand in hand. And of course, the architect will certify anything that the developer wants. I'm sure all of you know about the Majestic Heights case, right? Where the architect certified and issues all kinds of certificate when the doors were not even fixed and the building was apparently certified as completed. Of course, huge problem. Now it's sorted, but architects were involved there. So I think every now and then, every professional needs to be reminded what the boundaries are. Sometimes it's difficult because of your relationship with your client. Lawyers get it too, right? Because we have HDA accounts, and every now and then the developer will say, can you please release the sum? No means no. I mean, that's obviously a criminal offense. The lawyer actually releases from his HDA account and certifies the HDA account. Right? So things like that, of course, can give rise to negligence, apart from contractual breach. Because when you're employed, the contract would say that you're supposed to certify on the value of works. And if you over-certify, of course, there's a breach of contract as well. And negligence, because you failed in your duty, you did not act properly, you were reckless or whatever it is, so it amounts to negligence as well. So whether this is a case where it's a different scenario, so we'll go through it. Badan, Pengurusan, Bersama, Tropicana against Mutiara, Metropolis, Sdn Bhd. You may have heard of this case. So here, P is a joint management body of Tropicana Bay residents. P is empowered under Section 1432 of the Strata Management Act to represent the parcel owners of the housing project in these proceedings. I just want to stop here to say that we will not be going in detail as to your duties under parliamentary acts, your statutory duties. You have duties under statute, you have duties under bylaws, for example, and those duties are, I would call it, strict liability duties. They are also duties of an architect under written law, right? Not only tort and contract, but also acts of parliament and bylaws and rules and so on. So the first defendant is the developer of the housing project. Ivory Associates Sdn Bhd. We can name names because case laws are published. And once, again, it may not apply to you, but it's a very technical thing. Once matters are stated or conducted in open court, it becomes public knowledge. Right? There is no confidentiality any longer. Unless the court issues a gag order. You have been reading about gag orders in the newspapers all the time. Unless it issues a gag order. Or sometimes the court may say this particular part of the proceedings or the entire proceedings shall be heard in camera. It means that it becomes private. Usually when it involves sensitive matters, like if it involves children, it involves victims where you want to protect the identity, you'll be heard in camera. It's just a term. It doesn't mean that it's literally heard in camera. It only means that the court is close to public. Otherwise, you can walk into the public gallery in any court proceedings, any member of the public. So we can name names because it's out in the open. So Ivory Associates, remember, Hart is a main contractor engaged by the developer for the housing project. D2 is a subcontractor employed by the main contractor to install waterproofing works at the tower blocks and the facilities floor of the housing project. The main contractor also appointed the third defendant as a subcontractor to supply and install hot dip galvanized pressed steel, sectional water tanks with high density polyethylene lining for the housing project. P initiated a claim against D2 for loss, D means dependent, for loss arising out of the repair works done to rectify the purported defects in the common properties of the housing project, arising out of D2's alleged negligence. The question that arises here is whether D2, a subcontractor, owes a duty of care and tort to P or the purchasers of the housing project. When all the parties involved had allocated their risk in providing their respective rights and obligations under their separate contracts with each other down the chain of construction. Here, the issue that we want to look at or touch on is the question that arises is whether D2, a subcontractor, owes a duty of care and tort to plaintiff. Findings of the court: in deciding the above-mentioned issue, the High Court judge relied on the federal court decision in not really relevant. And this is what the court said. I'm guided by the federal court case of Lockcock Bing. There, the purchasers alleged that the project architect, right, had acted negligently in preparing the original layout plan, resulting in its amendment, thereby causing a delay of 8 years for the completion of the industrial buildings. So here they're saying because the architect had negligently prepared the original layout plan, it had to be amended. And because of the amendment, there was a delay of 8 years, right? The purchasers claim against the project architect, because there was a delay, for the financial loss, even though clause 7.01 of the relevant sale and purchase agreement provided that they can claim liquidated damages against the developer for late delivery of vacant possession. In Lockcock Bing, the federal court refused to impose a duty of care, you'll be glad to note, on the architect to the purchasers. There, the federal court held that the court must give consideration to the presence of a contractual matrix between the developer and the purchasers, which clearly defines the rights and liabilities of parties and their relative bargaining positions. There can be no action against the architect if the remedy asked for is specifically provided for in the contract. Otherwise, it has the effect of rewriting the contractual terms. Such claims must be dismissed on grounds of policy. So on grounds of policy, but what the court is really saying here is if the remedy is provided for in the contract, which is a common thing that all of us know, even non-architects, that most sale and purchase agreements, especially for development, housing projects, and so on, will have a LED clause. So if there is a delay, so here the court made a finding that no duty of care is imposed on the subcontractor as a contractor. This is something else, right? But coming back to the architect's duty, what we can take from that case is that if a remedy is clearly provided for the parties, the contracting parties in the contract, then the architect will not be held liable. Because if there's a delay, then you go against the party that promised you that it will be delivered within a certain period. Okay, so the architect will not be liable to the purchasers. But what then the other party can do is if they can show that they suffered a loss by paying the LED to the purchasers as a result of the architect's negligence, they can then probably bring the architect in as a third party or hold the architect liable. That did not happen in this case. It did not happen in this case, but that is the conclusion of what we can take away from the case is this. Okay, now we come to what is a non-delegable duty in tort. Generally speaking, an employer of an independent contractor is not liable for the negligence committed by that independent contractor in the course of execution of the task for which he was engaged. I think that's a general position that all of you are aware of. If you hire an independent contractor to do something for you, the independent contractor is liable for his own fault or negligence. It does not extend to the person who hired the independent contractor. But a non-delegable duty actually extends that liability to the person who hired or is in some sort of a proximity or relationship with that independent contractor. That's why, again, I'll quickly mention about hospital and doctors before we go on to that case law later. You may know that apart from government hospitals, all private hospitals and healthcare actually hire, you can't use the word hire because they actually enter into an independent contract agreement with a specialist. The specialists in hospitals, for example, are working for themselves. They have a contract where there is no employment. It's not a contract of service, it's a contract for services. Therefore, they're independent contractors. To put it simply, they only sort of hire the specialists hire the facilities of the hospital. They even pay rent. Sometimes they pay rent for the room, nurses, and equipment, and blah, 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 and so on. So they are, strictly speaking, not strictly speaking, they are independent contractors, clearly independent contractors. But recently, not recently, for some time, but recently it has been really expanded. Recently, the non-delegable duty makes the hospital liable for the negligence of the specialist, even though the hospital has got nothing to do with how he conducts his consultation or his surgery or his prescription. So that is now, you may have read in the papers early this year or sometime in the first quarter of this year, that decision prompted the hospital association, private hospital association, to make press statements saying that, look, this is now going to be passed on to the patients at the end of the day, because although we are not to be faulted, we still have to fork out the money to pay the patient who suffered. It's not healthy, but well, we have to live with it, or rather they have to live with it for the time being. The doctors and specialists are, of course, very happy because they are not the only ones who are liable. It doesn't mean that they escape liability altogether. They are equally and jointly liable. And again, going back to why the patients also bring in the hospital sometimes is because we all know that the hospitals have the deep pockets, right? I think that was the policy, although not stated in such clear terms. In fact, in this case, that was in fact the case. We'll come to that later, right? Remind me to come to that if I don't say why it was like that in the recent federal court case of Columbia, Asia. So that is the general principle, but an exception is a non-delegable duty. Again, we can mention names because it's clearly reported. So I just want to look at what this judge actually said in this case. So I'm just reading what Justice Marilyn, who is now retired, said about non-delegable duty, very briefly. So ordinarily, the law does not impose a personal liability for what others do or fail to do. This principle is, however, displaced with the imposition of liability on this other person or entity under certain conditions or circumstances. This liability is more conventionally known as can you hear me? So this principle, particularly in the field of medical negligence, particularly, but it's not limited to medical negligence, or in certain jurisdictions known as the law on bioethics. Is not new to our jurisdiction. In fact, there have been quite a few authorities on non-delegable duty even here, right? In Dr. Cock, the federal court recognized and adopted this principle of non-delegable duty of care as propounded in Woodland against Swimming Teachers Association and others, which we'll come to later. I will not go into Woodland's case, because the principle of non-delegable duty is actually extracted from this Woodlands case in England, and that case did not involve doctors or hospitals, right? Involved the local council, Ministry of Education, and the swim coaches, okay? Here, it was also revisited in the case of Dr. Hari Krishnan and another against Megat Noor Ishak. So that is a medical negligence case. Before I come to that case later, in Dr. Hari's case, what was decided as far as non-delegable duty for hospitals concerned is that if the patient does not, if a particular patient does not choose that specialist, then the hospital is liable. So that was limited to that basically. So when you go, for example, taking the hospital case again, if you go into a private hospital, now especially after that Dr. Hari's case, they'll always ask you to choose and sign. Some hospitals even ask you to sign that I have chosen so and so. Before this Dr. Hari's case, not all hospitals practice that. You have a list and they have an understanding of a sort of rotating system, you know, 1, 2, 3, 1, 2, 3, or whoever that's free on that day, they pass it on. But now they ensure that you choose your specialist. So Dr. Hari's case is that the anesthetist that was sued there was not chosen by the patient. It was chosen by the surgeon who was going to do the eye surgery. Okay, so therefore, they found the anesthetist to be negligent, and applying the non-delegable duty, they also held the hospital liable. Okay, we'll stop on this case and we'll come back to this later towards the end of the session, this Columbia Asia case. We'll look at other cases in Singapore and Malaysia. So non-delegable duties in Singapore, you may have come across this case. I think we also spoke about this case the last time we met here. The Management Corporation Strata Title Plan number whatever against Tiong Ik Construction, and another. Here, an architect is involved here. The appellant was the management corporation of the Seaview condominium. The first respondent was the builder, main contractor of the condominium. The second respondent was the architectural firm appointed by the developer for the construction of the condominium. The appellant brought a proceeding against a respondent for building defects in the condominium's common property, wherein defects, excuse me, wherein defects were caused by the subcontractor's negligence. Defects. The subject of the appeal was the appellant's claim that the respondents owed it a non-delegable duties to ensure that the condominium's common property were designed and built with reasonable care. So here the Court of Appeal, Singapore, said, in our judgment, moving forward, to demonstrate that a non-delegable duty arises on a particular set of facts, a claimant must minimally be able to satisfy the court either that the facts fall within one of the established categories of non-delegable duties, or the facts possess all the features described, paragraph not relevant here. However, we would hasten to add that A and B above merely lay down threshold requirements for satisfying the court that a non-delegable duty exists. The court will additionally have to take into account the fairness and reasonableness of imposing a non-delegable duty in the particular circumstance, as well as the relevant policy consideration in our local context. Therefore, it appears that Singapore does not require the satisfaction of the woodland features in every case. We'll come to the woodland features later. And even then, the requirements are only threshold, with fairness and reasonableness and relevant policy consideration seen as additional matters to be taken into account. We'll also come to the requirement of fairness and reasonableness policy considerations later. So in that case, the court held that the architect was not liable for the negligence of the subcontractor, and the non-delegable duty was not imposed against the architect because in Singapore, because of policy considerations as well, right? And also because not all the conditions set out in the woodlands case was met. Now, what is important to note from the decision is that the court did not say that non-delegable duties do not apply to architects. It did not say that. So if it satisfies all the conditions as enunciated in woodlands case, it may be extended to architects as well, right? That's a Singapore position. The other thing that the court observed there is, even if you satisfy all the conditions of woodlands, you can still apply the principle of fairness and reasonableness. Is it fair and reasonable to actually hold the architect liable, for example, or any other party when it comes to non-delegable duty? Right. So now let's look at Dewan Bandaraya against Ong Kok Peng and another. Briefly, the claimant wanted to collect some keys from a friend who was living in a unit in the cleaning flats owned by DBKL. Here, DBKL was sued. He then suffered severe injuries as a result of falling into a lift shaft in the flats as he was stepping into the lift shaft on seeing the lift door partly open. There was no warning sign or barricade of any sort placed at the lift door to indicate that the lift was not in service. The maintenance of the lifts was covered by a maintenance agreement between DBKL and a third-party independent contractor. The trial judge found in favor of the claimant and DBKL appealed against the decision. So what happened here was, there was, of course, we all know Petroleum Flats. It's owned by DBKL. They hired independent contractors to actually maintain and look after the lift. So they were actually servicing or maintaining the lift and they left the door open. Nothing to do with DBKL, right? Someone fell. So what the Supreme Court said was, on appeal, the Supreme Court dismissed DBKL's appeal. Of course, in the Court of Appeal and the lower courts, DBKL was held liable. insofar as a finding of liability against it is concerned, and held that the respondent fell through a lift door which was partly open, and there was no warning of any kind about the danger, as the lift was out of order and neither was there any barricade of any kind. This was created by such an extra hazardous act or omission. So this is another area of non-delegable duty. If it involves extra hazardous act or omission, involving special danger to the users of that lift, that the appellant could not escape liability for the injuries caused to the respondent. The maintenance of the lift was a statutory duty imposed on the appellant by the Factory and Machinery Act 1967, and DBKL could not escape liability by delegating it to a third party. A non-delegable duty to take care means, in effect, that the employer would have to see to it that such duty of care is exercised, whether by his contractor or not. Otherwise, he would be equally liable as the contractor, in addition, in most cases, to the liability of his contractor. So here, of course, they were also held liable under the Parliamentary Act, the Factories and Machineries Act, as was stated earlier. But this is one of the area of a non-delegable duty, hazardous act or omission. So this, of course, this word is hazardous. So if architects are going to hire independent contractors or subcontractors that involves hazardous work, then the non-delegable duty would extend to architects. So I'm not sure. Maybe later you can perhaps share what sort of hazardous work that that you may get. You may need to hire independent contractor for hazardous work. Does it arise at all? I'm sure you would use contractors if it's a build and design or design and build. I think it could be hazardous. I'm not sure. Maybe you can share later. So we're going to look at a couple of recent cases, just one recent case, and then we'll go on to the Columbia Asia case. So in this case, Hemraj and Co. and another against Thackrah National. The first respondent is a licensee under the Electricity Supply Act for the generation, transmission, and distribution of electricity supply. The first appellant, Hemraj, was the owner of the bungalow having, not relevant. The second appellant is a director, first appellant. TNB have a 132 kV underground oil field cable from PMU Kuala Lumpur City Centre to PMU Kampong Lanjut, which passes through and along Lorong 31 4, owned by Hemraj. Right? The path of the said underground cable runs across the front of the said bungalow below the road surface. Hemraj had appointed LCS Engineering Services as the engineer for the construction of the said house. In March 2013, LCS Engineering informed Hemraj that they would apply for the relevant approval from Indah Water to connect the sewerage connection from the said bungalow to the sewerage tank owned by IWK. For the purpose of the IWK connection, Hemraj had appointed the second respondent as the contractor to carry out the sewerage connection to the bungalow. The third respondent, Kiap Lake Construction and Trading, was to carry out the excavation works, and the excavation works were carried out on 13th November 2013. On or about 14 November at approximately 1:30 a.m., during a routine patrol, TNB workmen found evidence of soil excavation work being carried out at the site. Not bad, the patrol at 1:30 a.m. Not bad at all. Or somebody will complain. And found evidence of soil excavation works being carried out at the site, which was fronting the said bungalow, and found the said underground cable exposed with the presence of oil leaking out from the said underground cable. TNB workmen also found that the underground cable had been damaged by the excavation works, causing the oil leakage. The excavation works have been carried out without prior knowledge and or approval of TNB or DBKL. As a result of the excavation works and the damage to the underground cables, TNB sued Hemraj and the second appellant for the cost of the said underground cables for the sum of 3 odd million together with 25% administrative costs. That's very high. So the issue here, although it doesn't involve a professional, whether the first defendant owed a non-delegable duty of care to the plaintiff, but it's in a construction context, yeah. So it was held by the court, the principle of non-delegable duty of care was the imposition of a positive duty to protect one from harm. The phrase, the positive duty to protect another from harm, was not to be confused with the defining features of the special relationship which existed in establishing second category of cases. The second category of cases is the category that was decided in the Columbia Asia case. The first category is where it involves hazardous work, right? The concept of non-delegable duty of care has some drawbacks. Holding blameless parties strictly liable might seem excessive. However, the principle of negligence fundamentally enforces a duty to prevent harm to others. This principle also underlies non-delegable duty of care. This duty, as seen in Woodland, is quite restricted in its scope, no longer with that. Importantly, the federal court acknowledges that non-delegable duty is a heavy responsibility. It should only apply when it's fair, just, and reasonable based on specific situation. The federal court in the present case concluded that it's not right to make homeowners responsible for routine construction tasks through a non-delegable duty. This could unfairly make homeowners liable for contractors' action if they can't fully manage, causing unclear responsibilities. I mean, here, I am not sure why the courts did not hold that what the contractors were doing is a hazardous job. If I'm not mistaken, it was raised in this case, whether it was hazardous or otherwise. But the courts did not hold it was hazardous. I'm quite surprised with that, because I'm sure you can see it's a fairly dangerous work. And they left the cable exposed and the oil was already leaking. I'm not sure about that. The other thing is, this was decided in 2022 or 2023. By the time it went up to the federal court, it was 2023. What has been observed here, in my view, has been overridden by this case. Xiao Qingyi against Columbia Asia Syndrome Bahar. Because in this case, you would note that what was said in Hemraj's case was not considered. I think in Hemraj's case, what they did was, number one, it was a policy consideration, because it is quite common for house owners to hire independent contractors all the time to do from the smallest renovation work to building a house or major renovation works and expansion, right? So I think it was a policy consideration, which sometimes the court take into account, but they do not state it clearly. Like what was stated in the Singapore case, it was also a policy consideration. Secondly, in this case, rather in Hemraj's case, they applied the principle of fairness and reasonableness, whether it was fair or reasonable to hold the house owner liable for what was done by the contractor. So I think that applied. But now, this case, I just call it the Columbia Asia case, easier to remember, has, in my view, changed the landscape, if I may use that word since you're architects. I think, if I may dare say, altogether. Although this is a medical negligence involving a private hospital, we want to see whether it applies to other professions as well. But non-delegable duties does not only apply to medical negligence or hospital. You've seen from the other cases, it involves all the way to DBKL and so on. So here, the case of Woodland against Essex County Council, the court provided a rationalization for the imposition of the non-delegable duty of care, generally creating two broad categories of claims based on positive assumption of responsibility towards the victim in question, namely, where the defendant employs an independent contractor to perform an inherently hazardous or extraordinarily hazardous or liable to become so in the course of his work. In such situation, the duty of care cannot be delegated to the independent contractor, and the principal will remain liable throughout. Or second category, Woodlands decided on the second category, right? Woodlands, and so did the Columbia Asia case. It is, however, the second category which is of concern in this appeal. Lord Sumption in Woodland had formulated 5 identifying features in cases in the second category where non-delegable duty of care applies. Okay, so these are the 5 categories in the 5 principles in Woodland's case. The claimant is a patient or a child, or for some other reason is especially vulnerable or dependent on the protection of the defendant against risk of injury. So it covers quite a wide area. It's not only limited to a patient or a child, right? Because in this case, in Woodland's case, were school children, or for some other reason is especially vulnerable, children or patient. Again, that is connected to maybe people who are vulnerable, right? Or dependent on the protection of the defendant against risk of injury, whether it can be extended to architects or engineers, whether is dependent on the protection of, let's put it in our context, on the protection of the architect against the risk of injury. So if someone comes to you, I'm thinking aloud. If someone comes to you and say, please design a house, and I'm not sure whether it can be extended to say whether your design would involve them depending on your protection for a proper design, and if it collapses because of bad design, right? Number 2, there is an antecedent relationship between the claimant and the defendant, independent of the negligent act or omission itself, which places the claimant in the actual custody, charge, or care of the defendant. In some of the cases where non-delegable duty was not applied, some of these principles were not satisfied. For example, the Singapore case, which places the claimant in the actual custody, charge, or care of the defendant, and from which it is possible to impute to the defendant the assumption of a positive duty to protect the claimant from harm, and not just a duty to refrain from conduct will foreseeably damage the claimant. It is characteristics of such relationships that involve an element of control over the claimant, which varies in intensity from one situation to another, but is clearly very substantial in the case of school children. The claimant has no control of how the defendant chooses to perform those obligations, whether personally or through employees or through third parties. This is quite clear. The defendant has delegated to a third party some function which is an integral part of the positive duty which he has assumed towards the claimant and the third party in exercising for the purpose of the function thus delegated to him, the defendant's custody or care of the claimant, and the element of control that goes with it. The third party has been negligent, not in some collateral respect, but in the performance of the very function assumed by the defendant and delegated by the defendant to him. So, I mean, the last one, if I could just emphasize on the last condition, there must be negligence in the first place, right? If you employ independent contractor to do something, there must be negligence by the independent contractor in the first place. Just like when the hospital was made liable, there was negligence found on the part of the specialist. If there's no negligence, there's no issue at all, right? Nothing to delegate. The Woodlands case, right, also had a proviso an exception, right? So to speak. The reason why a hospital or school is liable is that the hospital has undertaken to care for the patient, and the school has undertaken to teach the pupil. And that responsibility is not discharged simply by choosing apparently competent people to do it. The hospital or school remains personally responsible to see that care is taken in doing it. Consequently, the imposition of this fair, just, and reasonable condition in the second category of cases concerning medical negligence does not arise. This is what the judge in our local case said, the one in white. The imposition of this fair, just, and reasonable condition, because in Woodlands, what the judge held was that, yes, we are going to impose non-delegable duty here, but generally speaking, you must also consider whether it's fair, just, and reasonable. But what our judge, Justice Mary Lim, said, that it doesn't apply concerning medical negligence cases. In any case, the respondent in this appeal is not rendering a public service. I'll explain this. As used and understood in the English cases, reliant on public funds through the system of taxation or voluntary contribution. It is a private business entity, she's talking about the Columbia Area Hospital, set up for the specific purpose of rendering private healthcare facilities and services, quite clearly for profit, is what I mentioned earlier. Deep pocket. When the statutory regime governing private healthcare facilities and services is scrutinized, this becomes even clearer. This statutory framework actually forms or creates the necessary relationship for which a non-delegable duty of care may be deemed to have been assumed. The hospital authorities were under an obligation to use reasonable care and treatment. They cannot get rid of that obligation by delegating it to someone else, not even a doctor or surgeon under a contract for services. So because the reason why she's saying this, she said this, I'll come to that case a bit later as well, some of the quoting her in some of the paragraphs. Although she said that medical negligence does not arise, you may think that this non-delegable duty, or what she stated in this case, only applies for medical negligence. No, which is not. She is saying the proviso of fair, just, and reasonable as propounded in Woodland does not apply in medical negligence cases. Because in Woodlands, although they found the ministry, the education authorities, and so on liable in non-delegable duty contacts, they still went on to say that, but you must look at fair, just, and reasonableness principle as well. It doesn't mean that you apply a non-delegable duty and you can't look at anything else. But Justice Mary Lim distinguished that or dismissed that principle when it comes to medical negligence cases, because in UK, the medical healthcare is provided by NHS, which is the government, basically. Which is why the non-delegable duty here does not apply to our government hospitals, does not. Because they're publicly funded. It's also a policy consideration. They're publicly funded. Whereas a private hospital is set up, like she set up very clearly, is set up for profit. Therefore, that principle of let's see whether it's fair and reasonable to make them liable as well goes out of the window. Only in that context. But it doesn't mean that non-delegable duty cannot apply to other professions or situations, right? I just want to go through some of her findings in this case. So briefly, what happened here was a patient, Xiao, was admitted, had a surgery, tonsillectomy and sinus surgery and all that. Went back 12 days later, he was bleeding profusely, couldn't stop the bleeding, and he was rushed to another hospital, to the emergency department. There was, of course, the ENT surgeon and the anesthetist who tried to stop the bleeding, and eventually, because they couldn't intubate the patient, the ENT managed to stop it physically by using his index finger and so on. And later he was intubated. Surgery was done. The surgery was done to correct that successfully. right? But because of the delay in intubating, he suffered from hypoxia, brain damage. I think he's still a vegetable until now. So it was very unfortunate. And the anesthetist was found to be negligent. And they found that it was the anesthetist that it was his negligence that caused the hypoxia. This case is also very sensational, if I may use the word, because of the amount of damages awarded in the millions. Because of aftercare. So, I mean, generally speaking, it's a very do not know what word to choose, but generally speaking, it's not a nice thing to say. It is much more expensive for the defendant if the patient is alive and needs aftercare. If the patient dies immediately or in a road accident victim, there is not much aftercare. There is not much pain and suffering. It's only for the dependents, not for that person. So here, there is a lifelong aftercare. He's bedridden. He can't do anything by himself, right? So that's why this case is also quite sensational. So here they sued, of course, they sued the hospital and the two doctors. ENT was not found liable. He was not negligent. As I mentioned, the anesthetist, of course, was found liable, negligent. And initially, the hospital was not. And on appeal, federal court eventually found the hospital to be liable because of applying all that. But apart from that, what was not really said is because the anesthetist was only insured for 1 million. Right? And the damages came up to millions. So who has got deep pockets? The hospital as well. I mean, the hospital, obviously. Right? So I think that may have played in the minds of the judges. There were 5 judges sitting in the federal court. 1 dissented, that means 1 disagreed. But of course, as far as our country is concerned, like most Commonwealth jurisdiction, you only go by majority decision. A majority decision is as good as a unanimous decision. That's the law. I mean, that's the only way it can work. So I just want to quote a couple of things. So in Woodlands, what happened was some coaches were hired independently for swimming lessons. Something went wrong, and a couple of kids, I think, had brain damage as a result. But the schools are, of course, all run by the Ministry of Education, together with the local authorities, which is why it's Woodland Against Swimming Teachers Association and Essex County Council or something to that effect. So here, she had set out all the 5 non-delegable features as set up as propounded in Woodland's case. We've gone through what she said about non-delegable duty. So she's also considered all this. I'm just reading out what she said. Despite these pronouncements, it appears the law on non-delegable duty, or rather its application, remains challenging in various respects, especially in medical negligence claims against private hospitals. Perhaps the process of distinction described by Lady Hale may have failed to make sense to ordinary people, because Lady Hale also found in the English cases that non-delegable duty should be applied in some circumstances. So what the judge is doing here, she's setting out, it's challenging, but she's already pointing towards the private hospital. So she's gone on the 2 broad categories as well. She's also, in this case, the hazardous aspect of Woodland's case was also mentioned, right? I'm not sure why even here hazardous category was not applied. don't you think that when a surgeon does surgery is hazardous? I would think so. I would certainly think so. I mean, it's a real dangerous job. Right? I mean, a person could die or be injured, like in this case. So I'm not sure why she did not, or the federal court did not take the hazardous category as one of the applicable categories. But it was stated. The other thing is, you may have heard of, she's also made a distinction that's quite a simple principle between vicarious liability and non-delegable duty. Vicarious liability is when a party is made liable for something that another employee or non-independent contractor commits. For example, employers are all vicariously liable for what their employees do in the course of carrying out the job. Of course, if they go on a frolic of their own or what they do in their private time is different. But whatever they do in the course of the work or at workplace, the employer will be vicariously liable because they are employees. They're not independent contractors. But if an independent contractor comes into the office to do some renovation work, or that is different. And that's where this non-delegable duty will be considered. Right? So that vicarious liability is very different. So she also quoted cases in Malaysia where the proviso in the Woodlands case was applied. For example, in Dr. Koch's case, and this is what she said. In Dr. Koch, this court had added that because non-delegable duties impose more onerous obligations, it would need the proviso in Woodland that such duty should only be imposed where it is fair, just, and reasonable. To do so, based on the particular circumstances of the case and develop incrementally from existing categories and consistently with underlying principles. But having quoted this case, she distinguished that case. She, as we saw earlier in White, she said that the proviso of even considering whether it's fair and reasonable does not apply in medical negligence. So at least there, we are certain that it is arguable that it only applies in medical negligence cases. It may not apply to other professions, or like in the case of, Hemraj that we saw. The other interesting fact is she also considered the Singapore case as well, but she distinguished all the cases. So just to make a note about the legal process when a judge or a court is deciding a matter, they will look at previous cases, right? And they are always guided by previous cases. And a lower court is bound to follow what the higher court has decided. For example, the High Court is bound to follow the decision of the Court of Appeal and the Federal Court. The Court of Appeal is bound to follow previous decisions of the Federal Court. They also, right, good practice, they also look at cases in other jurisdictions, because law doesn't exist only especially in a certain country, right? For example, our law is based on the English law because of the Commonwealth jurisdiction. And you would find that basically they apply principle of fairness really at the end of the day. It came from, of course, the ecclesiastical law, which is, or from Sharia, because they're all based on principle of fairness. So what the judges will do is, especially if they cannot find previous cases in this country, they will look at other jurisdictions and try to find similarities and where the principles came from and apply it. So what the federal court here has done is they've considered all these cases. They've considered Hari Krishn's case. They've considered the Cheong's case in Singapore. She's also considered other decisions like Hemraj's case. She's also considered all that. But despite all that, the court distinguished all the other cases and held the hospital liable here. And that is what we can take from this case. So that's all I'm going to refer to this case. But the principles that was held here is not limited to medical negligence. That was the point that I've been trying to make right from the beginning. The non-delegable duty was extracted from Woodland's case, which is not a medical negligence case, right, and applied here. So, as I said at the outset, so you can't say that, that involves hospital and doctors, so it doesn't apply to architects. But I'm of the view that it can apply to any profession as long as they fall into one of these two categories or both the categories. So especially architects, I think, because your job may involve hazardous jobs. So you have to pay heed to the non-delegable duty. And the other thing that was found in this case is that you cannot hold anybody else liable even if you have an indemnity agreement. So if you get an indemnity from your employer, you can't make your employer liable, right? Because what happened in this case, a specialist always signs an indemnity agreement with the hospital. Because the hospitals, of course, the hospital want to cover themselves all the time. They know that these are independent contractors, but we still, if we are made liable for in any manner whatsoever, we want you to indemnify it. So what happens in medical negligence cases, which I also do, is that if a patient is injured or harmed or dies, an action will be brought against the negligent doctor and almost always against the hospital as well. So what the hospital will do is immediately file an application for contribution and indemnity against their own specialists. So they just sit pretty there. Usually they don't get very much involved in the case. If at all, the courts find the hospital liable, they'll look at the doctor and say, pay up. In this case, the federal court even ignored that and said that no, because of what we have said about non-delegable duty and as to why you cannot delegate the duty, how can you then use the indemnity? It contradicts to what they found. So even if you get an indemnity now from any other party, you may not be able to enforce it. I'm saying may not, because this is very fresh. It's still hot, right? So now we have to look at ways of either getting around it or trying to distinguish this case or wait for another case to come out before the federal court or parliament to change. If parliament, of course, parliament can pass laws to change anything. At the moment, I don't think they are too bothered with the real stuff. So that's where you have to be careful as well, because you may not be able to enforce indemnity. So this case stands. It doesn't mean that it is bad. It stands. But maybe certain areas where exceptions and so on, maybe they should still open the door for exceptions to apply. The good thing is the court has held that it's only for medical negligence where the exceptions do not apply, not for non-delegable duty. And that's the way it works, as I mentioned. If you have a federal court case decision in this country, it stands until it is then overruled or set aside or distinguished by another federal court case on the same point, which is non-delegable duty. So the hospitals may get together the hospital, private healthcare organization may get together and say that, look, we have to instruct one of our lawyers to take it up all the way to federal court to try to change this decision, because they do not want any liability across the hospitals. But doctors are happy with this, because those days, everything will be thrown to the doctors and you guys deal with it. You just name as a dependent, it's okay. Right? So that brings us to the end of this session. A lot of you are quite tired. So what we'll do is we have a quick coffee break and then come and have, again, not so lengthy discussion. I think everyone did as well. So we'll come back in 15 minutes. Thank you very much. No, not really. Interchangeable. I mean, obligation is duty, duty is obligation. But as far as law is concerned, when we're talking about duty, we always use the word duty. There may be a difference because, for example, in contracts, you may have certain obligations. But if you really want to talk about definitions or meaning of a word, obligations are also duty. You have a duty to perform those obligations, for example. So the difference may be there, but I don't think it is really that, important. Legal-wise, I would say no, but legal-wise, when we talk about duties, it's specifically like, for example, duty of care. It's legal. We don't say obligation of care. So perhaps when you use the word duty, it is more sort of a mandatory thing that you have to do. Obligation, sometimes you're obliged to do something. It may not be yeah. Sure.
And also to High Court, same time. So when High Court make a decision to strike out the liability of architect, can KPKT or LAM, Lembaga, pursue the matter?
It is very difficult for me to say because that is not really legal, because your LAM and KPKT has got nothing to do with the courts. Those are internal things which regulates architects, right? It is not a strictly legal principle. For example, when you come to say, let's look at another profession. When it comes to doctors, for example, or when it comes to other professions, the High Court, the other way around, the High Court is not bound by what any other findings of any other bodies, including the ministry. The High Court is not. That's how the legal system works in this country and most Commonwealth countries. So sometimes when a doctor is found to have committed a misconduct by, say, MMC, the High Court is not bound by that. Misconduct, I mean, nowadays, they are framing misconduct to include negligence. So obviously, if they find misconduct, that means the doctor has committed negligence. But the High Court is not bound by that. The other way around, it really depends on your internal regulation. If your internal regulation, which I'm not familiar with, I'm a legal practitioner. If your internal regulation says that any finding by the High Court or any court of law shall apply in these proceedings, there may be, I do not know. Or it says that this is independent of any finding of any court of law or any other body, then it is independent. But usually for professional bodies, it's independent. Because I'm just thinking very widely. Yeah? in the courts and maybe your internal bodies, your LAM and KPKT, whatever. What happens in courts is it's a civil matter. When one party sues another party, for example, that can be withdrawn, that can be settled, anything can happen there. But I'm not sure whether any complaint to your internal bodies can be withdrawn. Sometimes some bodies do not allow withdrawal. Or some bodies say, even if the complainant is withdrawing, if your internal body deems fit, they can continue. So you really have to look at your carry from your internal body. Would the High Court look at it? The High Court would look at it. It may be persuasive. Obviously you can use that because High Court is our court. It's our High Court, right? So if you go to your body, look, High Court has found this, but you see different considerations may apply to different bodies. An internal body may be looking at it from a disciplinary point of view. High Court looks at it from negligence and legal point of view. High Court is not really bothered about your internal discipline matters. So it really depends on the context. I mean, it's a very wide question, sorry. If it's on the same issue, it may. The High Court is dismissed, yes, of course. On that very issue, yeah. Of course, it should carry weight. It should carry weight. It should be taken into account, unless your regulation says that we are going to ignore everything. So I mean, you may be asking about a real situation, right? Like what we've been saying before, everything depends on a case-to-case basis. There are no general answers. So especially if it's a pending matter, no lawyer can give you a general advice. So you really have to look at everything, all the regulations, what happened in the High Court. I mean, it is one thing, generally speaking. It is one thing for someone to come and say, High Court dismissed already. Or what did they dismiss? You have to go through the entire thing. What was argued in court? Like you see the decisions of the court, sometimes are hundreds of pages. So what did they consider? On what principle did they dismiss? Did they dismiss on a technicality? Did they dismiss on substantial merit? What was argued? So nobody can give you an answer like this. Anything else? Yeah. No other burning questions. I propose that we stop here because Mr. Victor has to speak as well. Thank you again very much. Thank you.